I will now request the clerk of the court to please read the first charge for today.
I will be reading the first charge that you can find in the charge sheet in the dossier that was placed on your seats upon entry. The first charge concerning commerce, past, present and future in Europe. And it reads as following. Defendant number 1, Airbus, jointly and severally with defendant number 2, the State of the Netherlands, is charged with committing crimes under Section 3 of the Intergenerational Climate Crimes Act in Europe by engaging in the following activities. It is alleged inter alia that 1. Airbus acts as a mercenary by designing, manufacturing and selling weapons of mass destruction, knowing that those weapons are intended for inflicting serious injury and killing of communities and destroying ecologies in the weakened and poor states outside Europe. 2. The State of the Netherlands took a leadership role in Europe in 1948 to establish the North Atlantic Treaty Organization, or NATO, and formed a consortium of European states that could collectively wage wars against other weakened and/or poorer states and profit from the wars by using weapons of mass destruction produced by Airbus. 3. That the State of the Netherlands allowed Airbus to establish its registered office in the Netherlands to empower Airbus to produce weapons of mass destruction. 4. That Airbus spawned an extended family of Airbus corporations as legal persons across Europe, all of whom engage in production of weapons of mass destruction with the intention of escaping responsibility for their action. 5. That the State of the Netherlands has joined all the major wars waged by the United States of America against the weakened and poor states around the world, including the War on Terror, with a view to profiting from these wars and thereby compromise the independence of the Dutch people and reduce them to a subservient state of the United States of America. 6. That the State of the Netherlands misled the people by signing international treaties on arms sales and arms control, wrongly leading them to believe that the Netherlands had peaceful intentions towards weakened and poor nations outside of Europe, when in fact it was providing legal channels and basis for aiding, abetting and inciting Airbus to expand its extended family network of Airbus corporations through multiple nationality, subsidiarity and transactional arrangements. This was done so that Airbus could continue to design, manufacture and sell weapons of mass destruction, and so the State of the Netherlands could use and profit from the use of these weapons under the shield of the North Atlantic Treaty Organization, or NATO, of which it is a member. These activities, if proved to be true, constitute intergenerational climate crimes against past, present and future generations of humans, non-humans, cultures and ecosystems under Section 3A, B, C, and D of the Intergenerational Climate Crimes Act.
I will now call upon our first witness, who's Valentina Azarova, to present her evidence before this court. Valentina Azarova is an international legal academic and practitioner and legal advisor to the Global Legal Action Network, or GLAN. Valentina will address the court directly and use slides in support of her presentation. Thank you.
Thank you. It is an honor to have been invited by this People's Court to testify about the legal frameworks that facilitate and enable arms trade, to situate them in a wider political, legal, and societal context, and to identify areas that need to be rethought by social justice movements as part of the paths of action in defense of climate justice for humans and non-humans. First slide, please. Specifically, the aim of my testimony is to assist the court to understand the role of existing laws, legal institutions, and procedures that purport to regulate the arms trade in legitimizing participation in violence, and obscuring the relations and responsibilities of state and corporate actors, and in denying access to justice for structural violence, such as in the case of Yemen. My experience and relative expertise in this area includes 15 years of practice and research in international law and various work more recently that has produced key revelations about the operation of the laws that enable and facilitate arms trade, to which I will speak, from investigations by the media group Lighthouse Reports, to which I assisted, and the ongoing interrogation of domestic institutions through legal mobilization related to the Yemen conflict by various social movements, some of which are represented here visually. While this knowledge is being produced and is held collectively by affected communities, social movements, and various legal groups, there are differences in organizational missions and approaches to the role of law, to which I will come back and close, that have contributed to the lack of coherence and momentum for change. Next slide, please. The ATT came into force in December 2014 after several years of negotiations due to the influence of hegemons, including the corporate lobby. Many of its key provisions were either watered down or rendered indeterminate. And more importantly, the treaty's implementation was relegated to states' domestic implementing regimes, including national export control laws, institutions, and procedures on which the treaty provides no guidance and for which it provides no form of international monitoring or enforcement. In the absence of any international oversight, the ATT casts national licensing authorities as the key implementers of the treaty, subject only to very limited supervision by domestic courts and parliaments. It is through this domestication of this international regime intended ostensibly to end involvement and profiteering of arms supplying actors in organized violence that the ATT became the infrastructure of irresponsibility and organized complicity for arms selling states and corporates. The treaty includes a twofold regulatory regime of prohibitions, one in Article 6 for transfers that occur in the knowledge of certain high threshold violations by the buyer, such as genocide, crimes against humanity, and grave breaches. These are extremely difficult to prove and have been interpreted evasively. 2, in Article 7, in case of transfers for which there is risk of likelihood of the arms misuse in serious international law violations. In practice, states have almost ignored the Article 6 prohibitions and instead proceeded to implement the future-facing risk test to all transfers in a highly discretionary manner. Next slide, please. This has included various dynamic interpretations, such as managing heightened risk through managing heightened forms of risk as short of overriding risk by stretching what is meant by mitigating measures to extend to political assurances and ineffective investigative mechanisms such as the one maintained by the Saudi-UAE coalition for actions in Yemen. It has also included disputing the seriousness of violations as isolated incidents instead of patterns and refusing to adopt positions on the legality of buyer states or on whether the assistance thereto entails the supplier's complicity. It has included emphasizing the misuse of the weapon type or even specific weapons sold by the supplier instead of paying regard to the general conduct of the buyer state, as well as privileging economic and political interests and relying on privileged information despite ongoing violations, and claiming that arms that would, quote, contribute to or undermine international peace are in fact forms of political leverage that could further peace. Next slide, please. This is further compounded by a set of structural exclusions of certain types of activities and control measures that are not regulated at all. Foremost, and most surprising perhaps, is the absence of an obligation to conduct any post-export controls after a license is issued. This means that states are only strongly recommended to do so, including in the latest amendments to the EU Common Position from 2019. Most states don't have any controls, and even though their companies and diplomatic missions are often aware and have been revealed to be so of information of serious violations, they are not required to act on such information in any way. Secondly, the relaxed and long-term licensing of post-sale servicing relationships, such as training and maintenance, which has included personnel of the UK company BAE being embedded in the Royal Saudi Air Force, or personnel and the company's offices of the French Naval Group being in a long-term partnership with the Egyptian army. There are also looser controls for joint projects, intra-European licenses, and other non-sensitive extent licenses. And finally, no controls for the actions of international organizations, such as the Organization for Joint Armament Cooperation, which is, along with Airbus, maintaining Turkey's air bridge with Libya. Due to the rigid secrecy around decision-making procedures, let alone specific licensing decisions, the dynamic and permissive interpretations that you see here have been exposed through independent investigations and legal challenges, especially in the Yemen context very recently, to which I will return. The ATT, in sum, has become a mechanism that successfully privileges state economic and political interests, akin to what Scott Weick calls a zone of non-responsibility, a zone in which officials are able to rely on their legal obligation as a way of evading the very question of responsibility and the consequences for their decisions. Next slide, please. Due to the monopoly that states maintain over the use of force in international law, the question of armed assistance is a serious political matter, and only states can decide on such transactions, whether they are undertaken by states or private actors. Several areas of international law include rules that prohibit assistance and aid to another actor's violations. In the international law of state responsibility, there are several forms of wrongful assistance. There are several provisions in thematic specialized bodies of law, such as human rights and humanitarian law, that define the principal violations, but also the ways in which bystander third states must act to ensure that their own actions do not harmfully impact the conditions and causes for violations to continue. What appears to be potentially powerful communitarian and solidarist norms have in practice at best indirectly informed judicial reasoning and governmental legal advice, and have been subject to a highly selective and politicized practice. Many exceptions to the point that they have seldom been adjudicated by domestic and international bodies. Next slide, please. To add to the elusiveness of such forms of shared responsibility, the ATT economizes arms supply relationships and subjects them to the liberal proceduralism of domestic export licensing systems, thus obscuring their inherently political function in state-to-state relations. By bringing them into the mercantile space, these dealings are then subject to regulation by the highly elusive so-called business and human rights soft law. These standards and complaint mechanisms under which businesses' home states are required to encourage businesses to self-regulate, and companies can pursue often subversive due diligence processes with a wide margin of mitigation and very limited forms of regulation for extraterritorial activities, which is in line with the limits of international human rights law. Business and human rights standards, therefore, have created a world in which NGOs are consumed with various implementation initiatives, contributing to a clear apology for the rise of the corporation to unprecedented influence and power under neoliberalism. The existence of separate legal lenses for states and corporate actors, next slide please, reinforces the division of labor between states and corporations, obscuring the way business dealings in this area are intrinsically linked with and service state political interests and are entangled with colonial continuities that pursue political subjugation and economic exploitation, only now mostly through state corporations. Meanwhile, in prominent cases, so-called defense cooperation agreements structure such relations, which in the case of the UK and Saudi Arabia date back to the 80s. One of these secret government-to-government agreements, signed in '86, and still governing UK assistance includes a blanket commitment to remain available for arming and support of the Saudi Arabian, of the Saudi Royal Air Force during active armed conflict without reference to the conflict's authorization or lawfulness, which was agreed by the UK Ministry of Defence against UK Foreign Commonwealth Office advice. Such agreements are explicitly excluded from the ATT's ambits, even though all sales are ostensibly regulated by the ATT. All we know is that both the agreements and their manifestly unlawful commitments and the supply relations have remained largely intact. Next slide, please. The ATT's consolidation of this disjointed framework for state and corporate responsibilities has further restricted possibilities to claim justice for the consequences of wrongful assistance. Efforts to challenge the enduring complicity of Western arms suppliers in the armed violence that plagues Yemen, an international conflict that began around the time, several months after the ATT's entry into force and has produced one of the world's worst humanitarian environmental crises, threatens the very inhabitability of the land, have revealed the rigidities and irresponsibility, the rigidities of irresponsibility, the limited oversight by courts and parliaments, and the limited remedies available to affected communities. The surge since 2016 in primarily administrative but also criminal challenges against governments and corporate officials in Europe, North America, even South Africa, counting around 10 jurisdictions altogether, have revealed a number of access barriers, including the lack of transparency, restricted jurisdictional scopes, and limited scopes of challenge. In various ways, despite concerted efforts and great ingenuity by affected communities, social movements, and NGO coalitions, these barriers and the limits of legal imaginaries bar the possibility of challenging the role of the political economy of the global arms trade in conditioning and fueling organized violence, even in the bleakest cases of protracted intergenerational processes of structural violence. The turn to the ICC by one coalition of rights groups as a form of structural critique of the legitimizing role of domestic and international laws in organized violence, though a far cry from what is within the reach of the ICC's current prosecutorial agenda, is one attempt to liberate from these structures. In close, the next slide, please. This devastating lived experience of transnational arms control laws provided by the Yemen context reminds those of us who work with international law that we should be more careful not to confuse our progressive interpretive agendas with the ways in which states and corporations use the elusive regulatory frameworks of the ATT, of complicity laws, and of business and human rights that maintain irresponsibility and collude with the hegemonic policies of neoliberal militarism. We should be looking to unthink and redress not only the persistent denial of unaccountable acts of violence conditioned by military assistance, but also the underlying policy preferences of the ostensible controls and checks in such laws. For instance, the way law structures the strategic autonomy of the so-called defense sector, while enabling justification and denial of responsibility for state-led military cooperation relations. In the interim, of course, some tactical work can nevertheless be done within such institutions, getting international bodies to adopt new approaches to accountability for military assistance, getting business and human rights institutions to set out clear responsibilities for the so-called defense sector, pursuing accountability through the International Criminal Court, domestic criminal trials to create social deterrence, and pursuing broader and more holistic reparation agendas by conflict-promoting actors as part of a broader restorative accountability agenda, including compensation for de-development and migratory reparations. While doing so, we should be more explicit about the ways in which our tactics are alive to hegemonic legal instrumentalism and human rights populism, and are committed to resisting and unmaking them. And that no legal fix will remedy the policy choices preferenced by legal processes and practice, and generative of the current injustices to humans and non-humans. Thank you.
Thank you, Valentina Azarova, for your expert evidence on the legal frameworks, asking us to unthink the law. I will now ask the judges if they have any questions for Valentina, Nicholas Hildyard, Rasigan Maharaj, Sharon Wen. Any questions or clarifications? Yeah.
So thank you very much, Valentina. Now, as I hear you speak as well, there are technical aspects which are raised, which seem, if you'd excuse this, quite dense. Yeah, and inside it, I'm sure, and that's what you refer to as the Imagineering, the frameworks itself. But I wonder whether it would be useful to all of us if we are quite clear about what it is that we are speaking about. From how I understood and what was presented and some of the other reports that you referenced, it seems pretty obvious. The object of these things being produced is destruction. So I wonder why we keep using all this other language to describe something like that. See, if it's a hammer, it does particular things. So this unthinking, for us to unthink, I really think we need to be quite clear about the industry that we're speaking about, its particular purpose, its evolution. And then, in terms of us thinking about the future, us also making a point, is this socially useful if its object is social destruction? Yeah. So, if you don't mind making a comment specifically about them, are all of this legal tract specifically designed to obscure the actual nature of the industry we're speaking about? Thank you.
To be very clear, I believe that the histories and the politics around these processes, the way certain instruments have been adopted, initiatives behind them, but also the way they've been implemented and the practice around them, has very unfortunately made possible neoliberal militarism in the ways that you have described. So I think the purpose is very much to enable the destructive potential and moreover to occlude and make less possible and potentially even completely outside of our reach the possibility of resisting war and even discussing the legality of war has become quite a common taboo within certain NGOs, within certain legal circles that unfortunately do take part in the neoliberal human rights project. I hope that answers your question.
Do you have a question?
Much, Valentina. A really excellent presentation and very illuminating. I've got a couple of questions. One is about the Arms Trade Treaty. What was it that led to the Arms Trade Treaty? What was being responded to? Why was there thought to be a necessity to bring in this treaty? Was there an effort to blunt something through this treaty? There's one question, and I'll come to the other one.
I think it's related to the previous question, of course. And it has many answers. I think a simple answer would be that a simple answer would be that Well, the industry took a very important part in the treaty's making. In fact, there was quite an unfortunate hijacking of the negotiations process. A very, very sad story of that, and I think Vandela might also offer some thoughts to that. So it's very clear whose interests prevailed. The industry's interests. And states, of course, in the state corporate tie-ups have a lot that they want to achieve and accomplish through the industry. So the model of state corporations in this area of military and so-called defense cooperation with other states and its interlinkages with political influence and trade and so forth as new forms or continued forms of colonial domination. I think that those were embedded in the ways that the supposed regulations, right, that what we imagine to be tools that are supposed to constrain such trade and such activities, have actually turned out to be to service and enable a very different kind of and set of activities.
Just to be clear, was the treaty a response to growing resistance against the arms trade, to concerns in the wider public about the arms trade, and to calls for real regulation with teeth that would have perhaps blunted the arms trade?
Absolutely. The treaty was a response to outrage, both by civil society and social movements around, for instance, the fact that the arms used by the Saddam Hussein regime were provided by Western nations, but also the amount of human suffering that was being caused through arms trade. But it is the process of negotiating the treaty. That was the point at which different interests prevailed.
To be clear, the Netherlands is a party to the treaty and was part of the process that the Netherlands government. Was it, in your experience, on the side of those who wanted stronger regulation, or was it part of those who have thought to blunt regulation through the treaty?
I believe that I do not know exactly. I can come back to you on precisely its position throughout the negotiations, but my understanding and recollection is that it was certainly not on the side of those who were looking to genuinely negotiate a treaty to end harmful arms trade.
And just a couple of, one question, just to clarify a couple of phrases you used. I think you talked about NGOs being swallowed up and co-opted, perhaps. Maybe that's what you were getting at. And also about human rights populism. And I wonder whether you could just explain those two phrases in a bit more detail and the extent to which whatever those processes are have made it more difficult to hold those who undermine the collective right of all to survival, which is how I take the treaty to be talking about climate crime, how that's made it more difficult.
Yeah. So human rights populism refers to various forces that have adorned themselves with human rights, but a certain type of human rights, a limited form of human rights. I think it relates to discussions earlier around greenwashing. So states primarily, but also the corporate sector and unfortunately also certain NGOs. Now, NGOs, which I think need to be looked at critically and carefully and more accountably, and as separate from those who always are seen as representing affected communities or as separate from social movements. Right? It's very important to make that distinction. And the reason for that is there are very powerful leading civil society actors, including the very well-known international non-governmental organizations we could name, that have limited mandates organizationally, that till this day are unable to speak to questions such as the legality of war, are unable to call for embargoes because they see them as political calls, are unable to call out and document actively corporate state collusions and tie-ups, because there's a certain level of apologism perhaps, but also tactical neutrality that they have adopted. They're also unable to speak of self-determination. There's quite a lot that certain leading NGOs are unable to do, and yet they occupy a lot of space and outcrowd often, and even sideline important other actors like peace movements.
Can I ask one more question? Yes. I think this is a very important question, an issue that's raised here, because obviously a court like the Intergenerational Climate Court relies on the public to enforce its judgments. There's no one else we can rely on. And what I'm hearing here is that at least some of the vehicles that the public may think are the organizing vehicles that might be used to enforce a judgment, whatever your judgment is, may not be necessarily, as they're constituted now, the right vehicles. And I wonder whether you could comment on that, and whether you see other forms of organizing that might enforce the judgment of the court better.
It's a very complicated question, and I think it's a question for all of us to answer. I think this is why we're all here. I feel very humbled to be part of this initiative as a very important one type of such initiatives, a people's initiative. So I think we need to critically look at such actors very much. I agree, and perhaps look at our own political and moral responsibilities in a very individuated way, but in a collective orientation, so as not to give away our power.
Thank you very much.
Thank you.
Sharon, yeah.
Thank you for that very interesting and informative information. I have two questions. So the arms treaty is not effective because it's infiltrated by the arms trade. I'm very familiar with that kind of thing. We've had the same thing happen to work that we've done on indigenous issues at the international level, so I'm quite familiar. But if we know the arms treaty doesn't work, do you see a process that could be reimagined to get something that would work? That's one question. I have a second follow-up question, but I just would like to, what's the next generation of this process, if I can ask?
I think there's a lot of unthinking to do at the moment around really many of international law structures, so it's very hard to take the arms trade treaty out of international law out of the arms trade treaty. In the broader sense, a lot of international laws mechanisms need to be re-understood towards redistribution and justice and real development in ways that there are many initiatives, be it Bandung or the new international economic order, that have pointed us in the right direction or tried to do so in the past, and perhaps it's from those we can pick up.
And just picking up on something you said about the NGOs, NGOs think that war and war machines have nothing to do with their work. So what needs to be done is to link that everything that they're doing relates to destruction of the creation or Mother Earth. And so they can't abdicate their responsibility by saying it's not my mandate to talk about war, but let's talk about, I don't know, clean drinking water or something. But you can't have clean drinking water if it's being polluted by war machines. So I think what you're saying is there needs to be a rethink. I don't want to put words in your mouth, but a rethink about what people are doing into the future.
Yes, you are not putting words in my mouth. I think there are different ways of putting that, and re-understanding, completely unthinking the way we approach specific rights is part of what is absolutely needed, because the example of water, as you pointed, it demonstrates the extent to which we neither appreciate the temporality of certain, the intergenerational aspects of certain human rights abuses, nor are able to appreciate the true root causes of exploitation due to these occlusions, such as the inability to speak to political phenomena, such as war.
Thank you very much. Thank you.
If I may just put one question to you, Valentina. You explained to us the legal infrastructure that allows Airbus to continue to do what it does. And from what I understood, the Dutch state, along with other states, create this legal infrastructure that makes it appear that they are standing for peace, but actually allows Airbus to conduct its business and also helps it to go and bomb countries or sell arms to other countries. I want us to assume that most Dutch people are peace-loving, that they care deeply about justice, and that they really want a better world. Yeah? Based on that assumption, the Dutch government tells them, we need to support companies like Airbus because your jobs are tied to that. If Airbus shuts down, you will all lose your jobs, you won't be able to feed your families. So, and therefore we just need to do this. And our way of doing it is to have this infrastructure that allows us to speak about peace but actually wage war. So how should Dutch people look at this role that their government is playing? On the one side supporting Airbus, on the other side supporting their desire for peace, and on the third side, holding out this carrot of a job that is going to come from these industries. So there is a tension there. I know this is a difficult one, but this is something that our jury will have to reflect on and come to a conclusion. So if you can just share your thoughts on that.
It's a very difficult.
It's a big employer.
Yeah. That's why this isn't an issue that can be looked at in isolation from that isn't probably an easy question to answer for a lawyer. But I think there are there's a lot of information that isn't available to us about those decision-making processes. So I would start there. Do we really understand why these decisions to continue to support this industry from the highest political echelons are being taken? Are they really for the labor market? And I would question that. I would also question whether those are the only ways in which jobs can be guaranteed. And surely I would imagine that societies, our constitutive commitments, should not permit us to allow jobs to be produced, to be maintained at all costs. Right? I think there are also greater costs that we don't understand for maintaining such jobs. Right? And I think that really takes so much more than what I personally could provide on this subject matter, but I think asking those questions and interrogating the extent to which we really are allowed to know and participate in these decisions and claim that role to be there and participate. I think that's where we need to start.
Thank you very much. I now invite members of the jury, if you have any questions for Valentina. Yes?
A very practical one, actually, because the former speaker said they have a small share in Airbus to be able to keep track, let's say, of what's going on. But who are the main shareholders, the owners? Or
Maybe Vandela is much more knowledgeable.
Well, for Airbus, this is partly the government, so the French and the German government, us. It's partly the banks, like ING is shareholder, and it's partly private investors. So you have a very little say in that, and it's the disinvestment of these kind of companies by pension funds, for example, and banks, is a strategy to limit their working space, but it's not enough. It's one of the strategies we should definitely use.
Any other questions? Yeah.
Thank you, Valentina, for a completely shocking presentation. I have several questions, but I will ask one. You referred several times, which I think is a very interesting question too, that certain NGOs are unable to discuss the question of the legality of war. In your opinion, what is the legal ground for war, considering the fact that it always implies destruction of ecosystems, human lives, environments? What is its legal ground?
Yeah, this is where I would cut off the branch I'm sitting on as an international lawyer. I don't think that international law currently provides an adequate framework to challenge war. So I think speaking to the legality of war is really also about unthinking that legal framework. There's a lot there that I wasn't able to cover as well. Yeah, there's certainly an appropriation and instrumentalization of the laws of the UN Charter in ways that have permitted war to be legal, even when it is when recourse to law is had by states that go to war. Right? Not all states use law to justify their wars, but those who have rewritten those laws to a great effect. So if we could seriously take on the task of that human rights populism, right, then we would be in a better place at least. But the fact that that is a taboo has allowed war to be normalized and sterilized in a sense, cleaned up.
Mm-hmm. Anyone else? Any further questions for Valentina?
Maybe I have one. Oh.
Yeah.
The guy with the microphone has one. Sorry, I have to check my notes. So I want to refer to some research that I read in Amitav Ghosh's book, The Great Derangement, in which he cites additional research that shows that at least in the United States, the Department of State that has the largest investment in development and research regarding climate change is actually the Defense Department. He also quotes top officials saying that for them, the climate crisis is a top priority in terms of defense, which is, of course, particularly schizophrenic for them to not commit to real action, but at the same time investing to prepare, which means they accept that the danger is real. So my question is, how much is this situation similar or not similar at all in the case of the EU and the Dutch state, for example? And also how much development and research for the climate crisis is being, how would you say it, conceived as in terms of defense? If, of course, any of this is available. If not, your opinion is good.
I feel like Vendela, again, may be better positioned to answer this. I haven't looked into that question myself, but I'd be to try to come back to you on that after the break. Maybe we can collectively come up with an answer, look into that. Or Vendela maybe has an answer.
No, many. I don't know the research you're talking about, so I'm very interested. I will meet you after this session to have this. Many figures are not there, of course, because the governments or the people who have a lot of money to do research do not use these figures, do not need these figures. It's the civil society that needs these figures, it's action groups that need these figures, and they do not have a research budget. So I do not know the exact amount. There is a recent research comparing the border security budget, I think, of the European Union as compared with the climate change, climate transition budget. I haven't read it yet, it just came out a couple of days ago. So there are people trying to compare these figures, but you can imagine that the arms industry got much more money than the climate transition research, where I also think that climate transition research, when it is technological research, making more interesting technological fancy things and buying ourselves out of climate crisis with all kind of new inventions, is actually not really the way out of the problem.
Thank you. Thank you for that. Anyone else has a question for Vendela or for Valentina? Any questions? Yeah?
I just take liberty to give a little of the answer that you also tried to answer as what is a driving force for governments to continue to support this arms industry, this arms export. It's also because they want to have these weapons themselves. So if you make weapons, it's very expensive. You have to put a lot of money into research because it's very specified technology, so it's very expensive. So the more you sell from them, the more you earn back this investment cost. So when you want to have cheap weapons yourself as country, you also have to export as much as you can. So you make weapons to defend yourself, and then you export it so you can be attacked, and because you want to have cheap weapons. It's a strange circle, but this is a very important driving force of governments to continue to support export.
Thank you. Yes, you had a...
So, as I hear, especially the last part of what we've been engaging about, there's something I want to, that we put on the table and be quite clear about. And on one of the slides, if not in both presentations, this lack of transparency gets repeated, especially when we talk about this specific industry itself. Yeah? But at the same time, these industries are located within a political space that's legally defined. In other words, there are budgets that are passed, supposedly by representatives of yourselves that you elect. Yes? And it's quite important then, in terms of those decisions that are made, that there is levels of transparency. In other words, you don't pick up your hand and say, I vote, but I don't know what I'm voting for, but my hand is up, please count it. You know, what I'm suggesting is, and maybe you don't have the answer directly, but it is something we need to bear in mind. You see, because this aspect that's being raised now is also about what constitutes the cost, especially when I heard the last part, this transactional element. Well, if we've invested, we should sell more and we'll get the money back. But that's not the cost. I hope I'm being clear about this. This is not a true cost that's being reflected. Yeah? And you know, this is quite important. There's a whole range, there's a whole state infrastructure that appears to be supporting this as an industry. All of those wider costs are not included. When the budget is chosen, X amount goes to a Ministry of Defense. Yeah? And we need to be quite clear about this. Even if all of those costs are not accounted for, it has been voted for. In other words, yeah, every citizen that's part of that legal system has voted for those instruments of destruction to be created, whether they are sold or not. So, you know, I think this is something that we need to be quite clear about. Yeah? It's not that it's something taking place just commercially. There's active agency in their creation, and once they are created, that destructive potential is amongst us. I'm sorry, I had to make that point.
Take that as a
Please.
comment rather than a question. Yes, thank you. Yes.
Last question from me, and it's actually it's probably to both of you. But many of the slides we saw were about the impacts of arms exports abroad. So pictures of Yemen. I think there may have been Lebanon there too. But what I'd like to ask is whether, in adopting a war room mentality around climate change, it is not just those abroad that are now being subject to the security apparatus that is inherent in a military regime, military apparatus, but whether some of the technologies that Airbus creates, and particularly surveillance technologies, are or will be, in your view, used against Dutch citizens here who happen to take a different view on how to address issues of climate change, how to address issues of migration that is stimulated by climate change, and indeed who happen to oppose the arms trade as a cause of the climate, as a climate crime. So I'd like to know what sort of domestic surveillance there is and how it fits into a response to the climate crisis.
It's a bit outside of the ambit of what I've studied for this purpose, and I think, again, I'd like to invite Vandela to see if she has any responses, because I would come back to you on that in regards.
I'm not sure I completely understand the question. You're talking about surveillance technology equipment being used on activists.
If they oppose the government's position on arms trade and on Airbus.
Specifically on Airbus?
No, or generally if they oppose government policy, then what is the likelihood that those technologies, which are now being used elsewhere, will be used against Dutch citizens?
Let me put it like this, that Airbus is clearly part of a national security apparatus. Is the climate crisis redefining who are security risks? And are the technologies that are currently being developed by Airbus likely, or currently, are they likely to become technologies that are employed against ordinary Dutch citizens who happen to take a different view on what the way forward is out of the climate crisis?
Yes, that's quite scary questions, because now we're talking not only about what these arms are doing outside our country, but actually to us. Well, what you see in Dutch policy is that, and you see it also in other countries, that the line between police and military equipment is getting blurred. You saw this Minipol arms fair, and you see it happening in many countries already. It's also I know it for the Netherlands that it is in the defense strategy that the military should get a greater role in controlling internal situation. So you see the first steps in that drones, which Airbus is also producing, are being used more for crowd control. You see it with another military company, Thales, who is also doing a lot on border security, is also more used in the Netherlands for things like control. I think you can predict that this will increase unless we try to stop it. But what I see is that the forces that are trying to stop it are not really very strong. I think people are not really aware of where this is heading to.
Thank you very much. Yes?
Just very briefly add that there are certain conflicts in certain contexts. For one, the siege on Gaza, which has become a laboratory for testing all types of technology, and that certainly comes back to reinforce the development of certain technology, and the same goes for surveillance technologies used in countries like Turkey and Egypt and so on. So of course there is a loop back effect in terms of the development of these technologies, which is completely unregulated. There are no regulations on imports when it comes of information that is produced through the use of items. There's barely very much regulation on intangible sort of information that is exported as well. So there are many more loopholes than I was able to really, or by design, that I was able to cover.